Hello everyone and welcome to FALAS Ghana Video and Infographic Case Series. This week we have a whole lot in store for your criminal law studies. Do enjoy our package. We're looking at a truly classic piece of Ghanaian jurisprudence today, NYAMENEBA and Others v. the State. It's a landmark ruling from the Supreme Court all the way back in 1965.
Let's dive right into this explainer. Our agenda for today is pretty straightforward. First, we'll look at the herbs of life, then the legal issues, the whole chemist report situation, the crucial difference between ignorance of fact versus law, and finally, the verdict.
All right, part 1, the herbs of life, a curious case in Princess Town.
So the facts of this case are honestly pretty wild. We're looking at a religious sect down in the western region. For over 4 years, they were openly cultivating a plant. And I mean, openly. They burned it as incense, they made soup out of it, they used it as medicine, and they called it, without a hint of irony, the herbs of life. And here's the kicker. It was actually this super earnest belief that caused their downfall. Look at this timeline. The sect members actually went out and complained about the town's youth drinking and smoking. They made themselves such a nuisance preaching about it that on Christmas Day, 1963, the town elders complained to the local chief. When the chief sent his reps to calm everything down, the sect members literally whipped out their herbs and smoked them right there on the spot just to prove how holy they were. The chief's men, probably thinking, wait a minute, this smells like Indian hemp, marched them straight to the police. And having zero guilty conscience, the sect willingly led the cops right back to their farm. You literally can't make this stuff up.
Just to give you a sense of their absolute, unwavering conviction, listen to what the second appellant actually said on the record during the trial. He proudly told the court, "My leaves are leaves of life. I smoke the leaves which give me wisdom, understanding, and strength, so that I don't do after some other people live. I don't steal. When I smoke the leaves, I don't drink." In Genesis chapter 2, verse 9, the leaves are referred to. Right? This wasn't some clever cover story cooked up for trial. This was genuine religious conviction. They acted in absolute good faith, truly believing they'd found some sort of holy biblical plant.
Moving on to part 2, the legal issues, unpacking the charges.
Well, the authorities? Yeah, they weren't exactly swayed by the biblical defenses. They charged the sect under the Pharmacy and Drugs Act of 1961 for cultivating and possessing Indian hemp. And this, right here, brings us to a massive pivot point for your criminal law studies. Does merely holding a prohibited item automatically make you a criminal? Think about it. If someone secretly slips an illegal substance into your backpack and you're just walking down the street physically possessing it, are you guilty of a crime? Keep that fundamental question in the back of your mind as we go through this.
Part 3, the chemist's report. Let's talk about prima facie versus conclusive evidence.
To prove these plants were actually illegal, the prosecution brought in a government chemist's report. The report certified that the herbs seized from the farm were, scientifically speaking, Indian hemp. But the appellants, they fiercely disputed this. Now, they didn't object to the certificate itself, but they insisted there had to be some kind of mistake. They actually demanded the chemist appear in person so they could cross-examine him. They genuinely believed they could convince a government scientist that his chemical analysis was wrong. The trial court actually agreed with them and ordered the prosecution to call the chemist to the stand.
And here is where we hit a really interesting procedural snag. The state attorney bluntly refused to call the chemist. He basically said, hey, the guy's out of the country, this written report is enough. But if we look at Section 121, subsection 1 of the Criminal Procedure Code, it dictates that a scientific report is merely prima facie evidence. Basically, it's accepted as correct until proven otherwise. It is not conclusive on its own. As the Supreme Court noted, if a defendant challenges that report, the prosecution is legally obligated to make the expert available for cross-examination. So the state attorney completely dropped the ball on procedure here.
But wait, here's the fascinating twist. The Supreme Court ruled that this missing chemist actually did not cause a fatal miscarriage of justice in this specific case. Why? Well, because the core legal issue wasn't the actual chemical makeup of the plant. Even if that chemist had shown up in court and mathematically proven to the sect that it was Indian hemp, it wouldn't have changed a single thing about what the sect honestly believed on the day they were arrested. A crime has to be evaluated based on the defendant's state of mind at the exact time of the alleged offense, not what they happen to learn later on during a trial.
Which leads us perfectly into part 4, ignorance of fact versus law. This is the absolute crux of the defense. Okay, so the law recognizes 2 distinct types of ignorance, and you really need to know the difference. First up is ignorance of law, found under Section 29, subsection 2 of our criminal code. You know the famous saying, ignorance of the law is no excuse. You can't just stand there and say, oh, I didn't know it was illegal to possess Indian hemp. The law expects you to know what is legal and what isn't.
But then we have ignorance of fact, under Section 29, subsection 1. This states that a person shall not be punished for an act if, due to an honest mistake of fact in good faith, they believe it to be lawful. Basically, a genuine ignorance of fact is a complete and total defense.
So, what did the original trial judge do with all this? Well, the circuit judge actually found, as a matter of fact, that the appellants honestly believed the stuff was the tree of life. But then, he convicted them anyway. I know, right? His reasoning was that they should have obtained the Minister of Health's permission to cultivate the plants. The trial judge treated their defense as an ignorance of the law, essentially punishing them because they didn't know the regulatory rules surrounding Indian hemp cultivation.
Thankfully, the Supreme Court stepped in to correct this massive error. They clarified that the appellants weren't claiming they didn't know the law against Indian hemp. They were claiming they didn't know their plants actually were Indian hemp. They were completely and genuinely ignorant of the fact of what the physical substance was. Because of that, Section 29(1) strictly applies here. They acted in total good faith, they made a mistake of fact, and that provides a perfectly valid 100% legal defense. And that brings us to Part 5, the final verdict, redefining legal possession.
The Supreme Court didn't just let the sect members walk and call it a day. They used this case as an opportunity to definitively rule on what constitutes legal possession in Ghana. The justices reached back to a precedent set just a year earlier in Amarte v. the State. They defined legal possession super clearly. Physical possession without knowledge is no offense. To be found guilty, you absolutely must have physical possession plus the awareness of the nature and quality of the article. In plain terms, you have to actually know what it is you are holding.
When you apply that rule to this case, the conclusion is obvious. The absolute prohibition of possessing Indian hemp under the Pharmacy and Drugs Act only triggers if the prosecution proves possession with knowledge. And the prosecution completely failed to prove the sect knew the herbs were Indian hemp. In fact, the defense provided overwhelming, conclusive proof of the exact opposite. They proved an absolute absence of knowledge.
So ultimately, Justice Olanunu and the Supreme Court allowed the appeal. They completely quashed the convictions and sentences from the lower court and entered a verdict of acquittal. The sect members walked free. But honestly, more importantly for your studies, this case cemented the precedent that legal possession fundamentally requires factual knowledge of the prohibited item. I'll leave you with this somewhat provocative thought. When does a genuine, maybe even foolish, misunderstanding cross the line into criminal liability? In NYAMENEBA, their deep religious convictions shielded them, because their ignorance of fact was truly in good faith. But as future legal practitioners, think about how you actually go about proving or disproving what is truly inside a person's mind. Keep that question in mind as you continue analyzing criminal law. Thanks for diving into this explainer with me today, and I'll catch you in the next one.